We're going to get started. First of all, welcome everybody. Thank you for participating. This is the second webinar that Dan has done for us, and I'm going to let him introduce himself. But you guys are in for a treat. The first one was very well received and a lot of great feedback and information on. But we want to make this as interactive as possible. So if you have a question during the question, or if you have a question, just type the question, send it to me, and I can ask him. If you think you have a microphone, you can raise your hand, and I'll call on you, and I'll unmute you, and you can get a part of that. We will, again, this is, if you take 3 of these sessions, this session, there's a second version and a third version, you will receive credit under the GMA and the ACCG discount and grant process. In order to get attendance, I'm going to send a message to you to send me an email, and I'll put my email address in that message. All I'd ask that you do is respond to that particular email that you are in attendance, and that's how I'm going to track your attendance. With that being said, I'm going to let Dan introduce himself and go from there. Thank you so much.
Okay, thank you, and thank you everybody for being here this afternoon. For those of you that I've not met at some point at a GMA or ACCG seminar, my name is Dan Niffen. I'm an attorney and partner with the law firm of Drew Uckland Farnham here in Atlanta. We also have offices in Brunswick, and I've had the pleasure of working with GMA and ACCG for, let's just say, a long time now. Try not to date myself too much. Our topic this afternoon, which we're going to take about an hour to cover, is beware your workers' compensation case is not just about workers' compensation, which may be kind of stating the obvious these days. There's a lot of things that come into play in a workers' compensation case these days, but we're going to go through several of the areas where workers' compensation intersects with other forms of employment law. We'll tell you kind of right off the bat, they don't intersect very well together, which if you've dealt with them before, you understand already. And we'll talk a little bit at the outset about why that is. And then we're going to cover about 5 areas, really. They're certainly not the only areas that workers' compensation gets involved with other areas of employment law, but probably the 5 most common. And they're definitely things that as an employer you want to be aware of as you're working your way through a workers' compensation case, because we certainly are. And we have to deal with these areas from time to time. The first is just in the area of hiring, and we'll talk about how that implicates workers' comp and some other areas. Return to work. If you have an injured employee and we're trying to get them back to work, that implicates a number of different laws these days, not just workers' comp. We'll talk about disability benefits. When somebody's out on workers' comp disability, how that can affect wage and hour laws. And we'll talk about 2 final areas that really come into play, probably more than the others combined. That's when we have what our Workers' Comp Act would think of as a catastrophic injury under our Workers' Comp Act, and how that interacts, oddly enough, with the Social Security laws that we have in our country. And then lastly, where these all really tie together, is anytime we're thinking about settling or resolving a workers' comp case, whether we're just going to resolve the workers' comp case or whether there might be some other potential claims or existing claims under other laws that our employees have that we need to resolve. So we're going to try to cover all those. As was mentioned at the outset, this is designed, and we hope very much will be as interactive as possible. So if at any point as we're going along here today you have a question, please speak up, send us an email, do whatever you're most comfortable with, and we'll be glad to try to address those questions, and especially want to hear from you if anything we're talking about kind of rings a bell with either an existing issue that you've got, or maybe one that you've dealt with in the past and you've kind of scratched your head and wondered what all that was about. So with that, we'll go ahead and jump right into it. Wanted to talk just very briefly for about 5 minutes about kind of how we got into the situation where workers' compensation isn't just about workers' comp. Why is it we're having to deal with so many other laws in the first place? To understand that, you have to kind of go all the way back to the beginning and understand that in a lot of ways, workers' compensation was what I would think of as our first employment law in this country. If you go back to 1920, when we got workers' comp in Georgia, and workers' comp is a state-by-state law. It's not a federal law. They're all state laws. It was based on the simple notion that if you get hurt at work we don't want to throw you into the general court system. So if you get hurt at work, it's a lot different than if you get injured in a car accident out on a highway somewhere. Those cases go to our state or superior courts, and they're negligence cases, or lawyers would call tort cases, and they get handled there. They tend to take a fairly long amount of time. They can be tried in front of a jury. The damages can include everything from pain and suffering to lost future income and a variety of things. Workers' compensation changed all that. If you get hurt at work, you don't sue your employer for negligence. You go to the State Board of Workers' Compensation because we have a very specific statute, the Workers' Compensation Act, that says you have a no-fault recovery if you're an employee and you're injured on the job, and your exclusive remedy is workers' compensation. You get some amount of your lost wages, not all of them by any means. You don't get anything for pain and suffering. You do get all of your medical benefits paid for, and you can get a permanent partial disability benefit if your injury results in some type of permanent damage. And as we're going to talk about, catastrophic injuries are treated differently, and you can potentially draw benefits for your entire life if your injury meets that particular definition. Now, the trade-off for all that is you don't have to prove negligence. You don't have to prove fault. You don't have to prove that you got hurt because your employer did something wrong or was negligent, as you might if you were trying to prove that somebody hit you in your car as you were driving home. But the trade-off for that as an employee is your benefits are more limited than you would get in another form of injury. The way employers benefited, frankly, was, even if you go all the way back to the 1920s, employers' entire businesses were threatened if they just had one bad case where somebody was severely injured. We tend to think of this as a fairly recent phenomenon, but it's really not. Businesses were concerned about this way back when. And so the trade-off for employers was you're not going to be able to defend these cases in workers' compensation if the accident was really the employee's fault, or if the accident simply wasn't your fault as the employer. It doesn't matter. As long as it happens at work, it's compensable, and workers' comp benefits get paid. Now, from those kind of humble beginnings, if you fast forward to our statistics from just last year, you can see that workers' compensation in Georgia, and it's true really in every state, has grown into a $1 billion industry. These are just the benefits that were paid on the cases that were open in 2017. Now, that doesn't mean, by the way, these aren't all accidents that happened in 2017. These might be accidents that happened 8 or 10 years ago, but the claims are still open. They have not been closed yet. So for all those open claims in 2017, $651 million in disability benefits, $700 million in medical, and a combined $1.3 billion. That's how much money gets paid out to injured workers on a year in and year out basis. And just to give you a little scale of that, you could combine all the car accidents, all the medical malpractice cases, all the cases you tend to read about in the papers where personal injury is involved, and nothing like $1.3 billion gets paid out year in and year out from those cases. So from its beginnings in the early part of the 19th century, workers' compensation has become a huge industry. And that's kind of the starting point for our discussion today. If you also go back to 1920, you would not have heard about any of these laws that have been passed since then that really do all have an impact in one way or another on just the average workers' compensation claim. Our discrimination laws, for example, which are found in Title VII of the U.S. Code, weren't passed until 1964. The Americans with Disabilities Act, which is a discrimination law, wasn't passed until 1990, and we all deal with that all the time in workers' comp now. Same thing with the Family and Medical Leave Act, which came along even just a few years after the ADA. There's a law we're going to talk about here in a minute called the Genetic Information Non-Discrimination Act, or GINA. I suspect many of you haven't even heard of that law, but it was passed just in the last 10 years and also has an impact on our comp cases. The Fair Labor Standards Act, which is our wage, where most of our wage and hour laws come from, minimum wage, entitlement to overtime, those kinds of things, that was passed in the 1930s, again, after workers' compensation. HIPAA, the Health Insurance Portability and Accountability Act, which affects privacy laws in workers' comp cases, passed in the 1970s and amended several times since then. OSHA, our Occupational Safety and Health Act, came along in the 70s. Our immigration laws have been passed since workers' compensation, obviously are much more in the news these days, and have been the subject of a number of workers' compensation cases actually in the last 10 or 15 years. We'll talk about that. Frequently, we have cases where folks get hurt on the job and they apply for unemployment benefits. And it's a surprise to many employers that in Georgia, you are perfectly entitled, as far as the law is concerned, to draw both unemployment benefits and workers' compensation disability benefits. It would seem kind of at odds to say, on the one hand, I would love to be working, but I'm unemployed, and so I want unemployment benefits, but I'm also disabled and can't work. And our courts have decided a long time ago that's not necessarily inconsistent, and so you can get both of them. You can, at least, if you wind up having to pay workers' comp benefits, get a credit as an employer for any unemployment benefits that you've also had to pay. You're going to see how, or we're going to talk about how Social Security disability, of all things, impacts our workers' compensation cases in Georgia. And of all the laws we've talked about, it might be the one that has the biggest impact, either that one or this one, what's called the Secondary Payer Act, passed in 1980, designed as a way to offset some of Medicare's losses and to try to help its financial stability. And we'll talk how that impacts workers' compensation as well. And of course, there's the Affordable Care Act, which is very much up in the air these days. But that was the first time really since workers' compensation where where we've had a law that says as an employer, you must provide insurance to your employees. That was always a voluntary benefit as far as group health care was concerned. And that obviously also has an impact on workers' comp cases. So the important thing to understand about all these employment laws, apart from what we just talked about, which is they all came after workers' compensation, and they were all passed at different times. None of them were really passed with workers' comp in mind. So they don't fit well together, really by design. They were not designed to fit well together. As this lady, Naomi Levin, said many years ago, she was one of the architects of the Americans with Disabilities Act. When folks in the workers' comp system after the ADA was passed said, hey, wait a minute, for example, what do we do when we're hiring folks now? The ADA says we can't ask about anybody's disability. So how are we supposed to know if we're hiring somebody who has a physical problem that's going to prevent them from the job and maybe they're going to get hurt and we'll owe them workers' comp benefits? And she very candidly said, gee, we never thought about that. This multi-billion-dollar industry was just kind of off everybody's radar. So it's important to understand, again, that these laws simply weren't designed to fit together. So if it feels like you're trying to put together a jigsaw puzzle that doesn't fit, that's understandable. And what you wind up having to do is simply go through the legal issues separately and kind of see where you come out. That's a little bit of what we're going to do here today. So I said that the very first area that this really becomes an issue is hiring. And the reason for why that's an issue in the workers' compensation world is we have this case, it's known amongst us lawyers as the Rycroft defense. And it very simply says that if you have somebody who, when you hired them, misrepresented their physical condition to you, lied about their condition, and because of that lie, because they deceived you in that way, they wind up getting hurt on your job. And the classic example actually is what happened in this Rycroft case. Mr. Rycroft went to work for the Georgia Electric Company, having had with his prior employer a workers' comp claim that resulted in him having a back fusion. When Georgia Electric went to hire him, they asked him, and this was in the late 80s before the ADA had come along, whether he'd ever had any workers' comp claims before, and he said, no, I haven't. And so they hired him. And within a week, he was doing some heavy lifting, and he re-injured his back at the very same place where the fusion was. In fact, the fusion in his spine broke, so it was a very serious injury. And the position Georgia Electric took in that case was, look, we shouldn't have to pay him workers' compensation because if he hadn't lied to us about having a bad back, we would not have put him in a position where he was likely to re-injure himself. And even though Georgia workers' compensation law says that aggravations of pre-existing conditions are compensable, this was basically fraud. If he hadn't lied to us, this accident wouldn't have happened. The Georgia Supreme Court agreed, and so that's been a defense ever since. If you can show that your employee misrepresented their condition, and this is important, not just that they lied, but because of the lie, there's actually a causal connection between what they lied about and the fact that they got hurt, then you don't owe workers' compensation benefits at all. So again, Rycroft case comes out in 1989. The next year, the Americans with Disabilities Act is passed. And one of the things it says is that you can't have any pre-employment medical inquiries or questions phrased in terms of a disability. So when the workers' compensation community said, hey, wait a minute, how can we be forced to hire people who like Mr. Rycroft, perhaps are not going to tell us about their back problems? And we could be putting them in a position where they're doing a lot of heavy lifting and they're just for sure going to re-injure their back. So the Equal Employment Opportunity Commission, the EOC, who oversees the ADA, kind of came up with a compromise. And this is what we've had ever since, going on 30 years now. You're allowed to, as an employer, despite what the ADA says, ask medical questions about your job applicants, but there are some very important bright lines that you have to stay within. The first is you can only ask those questions after you've made what the EOC refers to as a conditional offer of employment. So when you're taking applications, for example, you can't ask any questions about disability. When you're advertising for a job in your maintenance department, you can't include in that advertisement, by the way, we only able-bodied people need apply, or hey, when you apply on the application, we want to know if you've ever had a back injury. But what you can do is ask them the usual vanilla, what's your name, where do you live, where have you worked before, those kinds of things, and then offer them a job. But after you offer the job conditionally, and before, very important, before they actually start working, then you can ask them any question of a medical nature that you want to. The only caveats then are you have to ask those questions of anybody who's applying for that same kind of job. So you can't just pick and choose and say, I'm going to ask you these medical questions, but not you. And then you have to keep whatever you find out, whatever medical information you get, strictly confidential, which, by the way, is what you're supposed to do with any medical information about any employee anyway. So you're allowed to ask those questions, and using Mr. Rycroft again as an example, if you went through that process and Mr. Rycroft was honest and said, yep, I've had a back fusion, and he's applying for a job that just absolutely requires heavy lifting, then you might be able to respond to him that despite having made a conditional offer that, look, doesn't appear that you can do what the ADA would refer to as the essential functions of this job, even with a reasonable accommodation. So we're not going to be able to let you do this job. And there are actually some other steps that you might have to go through from there. But again, what you see here is there are very important reasons from a workers' comp standpoint why you do want to know what somebody's medical condition or medical capabilities are before you put them to work. And if you flip that example around that we just used again, you ask somebody the questions, and like Mr. Rycroft, they lie to you. And because of that lie, they later have an accident on your job, then you're still going to have this Rycroft defense because you're going to have something in writing that documents that they lied to you at the outset. So place number one where these laws start to intersect is in the hiring process. So, and that's where the ADA comes in. But this other law I mentioned just a minute ago, which we refer to as GINA, great example of how laws, again, have unintended consequences. I can promise you nobody was thinking much about workers' comp when this law was passed. And it was passed relatively recently by Congress in response to the fantastic developments in our scientific community that involve genetic testing, which advanced to the point where you can literally look at somebody's DNA if you care to spend the money to do that, and have a pretty good predictor of what they may be at risk for, whether it's heart disease or diabetes or any other type of medical condition or a large number of medical conditions. So Congress decided to say, all right, we're going to forbid the collection of this kind of genetic information in the hiring process. We don't want folks being discriminated against simply because their DNA test comes back positive for one thing or another, kind of similar to disability discrimination. But there is an exception for being able to ask this information, for example, if somebody gets hurt on your job and has a comp claim. But one thing that we've seen come up in the areas of law that I practice on, if you think about that little medical questionnaire that we give employees after we've made the offer of employment before we put them to work, what used to be on all those medical questionnaires was, do you have a family history of heart disease? And the reason for that is the single biggest risk factor for developing heart disease is if your mom or dad did. So most employers would ask that as a way of trying to figure out, is this somebody who's at risk for this? And if we know that, is it wise to put them in whatever job they're applying for? Gina would say you can't ask that question because it relates to genetic or family medical information. So one takeaway from this would simply be to review your health form or whatever you're asking employees in the hiring process, and make sure there are no questions there that relate to family history. A lot of folks who are aware of GINA have already gone through and done that, but if you haven't, that's worth a look. So one other area in the hiring process that comes into play. The other one is immigration, and this is one that, to my way of thinking, and certainly with every employer I've ever talked to, that the law just doesn't kind of make sense, at least the way the courts have come down on it. But we're all aware of employers of the requirements when we hire folks to make sure that they're here legally in the country, and that they have the ability to work legally, and that we have the legal right to offer them a job. There have been a series of cases, and they're cited for you here on the screen, where the issue came up where an employer hired somebody, thought that they were here legally, were either presented with a fake Social Security card or some other false form of information. So they were hired and then they got hurt on the job. And so workers' compensation benefits were commenced. And at some point after that, the employer becomes aware Social Security number is fake, the information we were given to begin with was false, and this person's actually here illegally. So the question then became, is that employee entitled to workers' compensation benefits if they're here illegally and really should never have been working in the first place? And what our Georgia courts have said, both the Court of Appeals and the Supreme Court, very clearly is the fact that your employee is not legal, even if they misrepresented that to you, does not prevent them from being allowed to draw workers' compensation benefits. And the theory, right or wrong, is that you've gotten the benefit of their work, whether that was for a few months or a few years. And since you got that as the employer, you shouldn't be able to dodge the responsibility for workers' compensation benefits. If we had time, I would argue why I think that's really not very logical, but that's clearly the law. What the law always also says, however, is, go back to this, is, and these cases have come up as well. So if that's the case, and you're my employee and you get hurt on my job and I start paying you benefits, and now I discover you're here illegally, I talk to my lawyer and he says, look, that's not a defense. We have to pay the workers' comp benefits. What's the next thing that usually happens in the case? Well, many times, not always, but many times, we're trying to get this employee back to work, to light duty work or otherwise, but now I'm aware you're illegal and I'm violating federal law to offer you a job, which creates a whole nother quandary. I've got to pay you benefits because my Georgia courts say I have to, but now I can't bring you back to work and suspend your benefits because that would be illegal and I'd be in trouble and violating federal law. So in their wisdom, our courts have looked at that and said, okay, we've already said you have to pay benefits, but if you're paying benefits to an illegal immigrant and they get released to light duty, then at that point you can suspend benefits because we understand you can't lawfully offer them a job at this point. So again, those two don't fit neatly together, if at all, but that is the law. And an example of another area of employment law that interacts with our workers' compensation system. All right, let's talk about the next two or three are really the topics that come up, I would say, most frequently when we're talking about workers' comp and other areas of the law. And the first one is returning folks to work. And there's several laws here that are going to come into play. One is the Americans with Disabilities Act. The other is the Family and Medical Leave Acts. We'll talk about them separately. And you really kind of have to because, again, each of these laws were designed in a different time and place and weren't really one was not really thinking about the other. So you kind of have to go through them separately. When we have somebody who's injured on our job and we're paying workers' comp benefits to them, the workers' comp laws have a very specific way of looking at return to work. And this is one place where employers kind of miss some things at the beginning. Nothing in the workers' comp law says that you have to bring somebody back to work. It says you have to pay them benefits if they get hurt on the job and it's a compensable injury. And it talks about in this statute 349240 about how you can, if you have light duty work that you think they can do, how you can get them back to work or suspend benefits if they refuse to do it. But it's really aspirational. It's not mandatory. Nothing's going to happen to you as an employer if you don't bring somebody back to work who's been injured on your job, other than you're going to continue to pay them benefits forever and ever, which is not a great thing. But there's nothing that says, hey, you have to bring them back to work when they're released to light duty. Now, what does say that is a different law. That's the Americans with Disabilities Act. Under the ADA, return to work is not just aspirational. It can be required of you as an employer if certain things happen. The first of which is your employee has to request a return to work. They have to request what the ADA would refer to as a reasonable accommodation. So how does that affect a workers' comp claim? Well, so if you're a city or county, you have somebody who's out at work on a back injury and they've been out of work for, let's say, 8 or 10 months. Maybe they've had back surgery, but now the doctor has said, okay, they can come back to work. They can't lift more than 10 pounds, but I'm going to release them to come back to light duty work, maybe 4 to 6 hours a day to start off with. So again, workers' comp, do we have to take them back to work at that point? No, it's a good idea if we can. because it suspends their disability benefits, and we're beginning the process of getting them back to work and reducing the exposure on that claim. So good, but aspirational under workers' comp. Under the ADA, you don't have to make the first move, and you don't have to go to this employee and say, hey, I'm going to take the affirmative step. It's not really an affirmative action statute. You don't have to go to them and say, hey, I see you've been released to light duty. Now I'm going to bring you back to work. But if your employee comes to you and says, hey, my doctor has released me to come back to work, I would love to come back to work. What kind of light duty do you have for me? What you can no longer do since the ADA was passed is just to ignore that. You have to at least consider that. You have to enter into what the law refers to as a case-by-case, good faith dialogue. What's reasonable light duty for one employee and one employer is obviously going to be different from employer to employer, from city to city, from county to county. So you have to kind of get in this interactive process with them where you're looking at them, you're looking at what their restrictions are, you're looking at what their job is and whether they can do the essential function of the job. That's the primary reason the job exists. If their job is sedentary, then having a back injury they can probably do almost all of the things that their job would require of them. And if the job were, let's say, a receptionist job, and that receptionist just occasionally might have to move a box or two just as to help out a coworker, that's not an essential function of the receptionist job. And it wouldn't be wise to refuse to bring somebody back to that job on the grounds that, well, you can't move that box that you might have to move once or twice a month. But same employee, same injury, same limitations, and their job is in the maintenance department where every single day their job requires them to move heavy objects. That person probably can't perform the essential function of that job, and there might not be a way to reasonably accommodate them. So that's just an example of the process that you go through, and how on the one hand workers' comp return to work is a great thing to do and to try to do in virtually every case, but is aspirational. With the ADA, you have to pay even more attention if you're asked for an accommodation by the employee. And the thing some employers miss with FMLA, Family and Medical Leave Act, would almost seem not to come into play with workers' comp, but it does. FMLA simply provides for 12 weeks of unpaid leave, not paid leave, but unpaid leave in a 12-month period of time if you have a serious health condition or you have a family member, spouse, a child who has a serious health condition. And workers' comp, of course, is a paid leave. There's a benefit that's paid for that. What you want to do as an employer, though, not that this is going to come up all that often, but if it does, you'll be glad that you took this step. Most employers kind of think or assume that FMLA doesn't start unless an employee asks for it. And since most employees aren't going to ask for FMLA when they go out on a workers' comp injury, it kind of never happens. But that's not necessarily true. The FMLA can be designated by the employer. So even where the employee is not asking for it, the law basically says that you as an employer are obligated to provide this 12 weeks of unpaid leave during a 12-month period of time for eligible employees. If they're out on workers' comp leave, in every single case, that's going to be a serious health condition for FMLA purposes. So it makes sense to start designating the workers' comp leave as FMLA leave as well. So they're running at the same time. And here's why, and again, it's not going to happen that often. But every once in a while, we have a case where, in fact, in my world, it happens more often than it might to an individual employer. You have somebody who's not a great employee, maybe they haven't even been there that long, and we've had all kinds of problems with them, and we're that far away from letting them go. And then all of a sudden, they have the unwitnessed on-the-job accident that we can't refute. We have real suspicions about, but it gets accepted as a comp claim. Benefits are being paid. And now this person's out of work for a while. And they come back to work and we're like, okay, now we're back where we were. We're just about to let them go when he got hurt, but he's okay now, he's back to work, so now we're going to let him go. And then he raises his hand and says, well, now wait a minute, now I want my FMLA leave. And FMLA says, you got to give me 12 weeks of unpaid leave, and you can't let me go. You can't fire me while I'm out on leave. And in fact, you have to allow me to return to the same or equivalent position when my FMLA leave is over. So it throws a great big monkey wrench into your desire at that point to let them go. So again, not going to happen all that often, but from experience, I can tell you, if you fall into that situation, you're going to wish that the FMLA had expired and they didn't have that card to play. So just as a routine thing, it's good to designate comp leave as FMLA so those two are running together at the same time. All right, very quickly on disability benefits, and then we're going to get to catastrophic injuries and settlements, because they They come up much more often even than these situations. If you've been at home recently, this is when I tend to see them. If you have the flu or something has caused you to be at home and watch daytime TV, you've probably seen advertisements from some of the workers' compensation employee law firms, one of whom is our good friends at Morgan & Morgan. If you've seen any of them lately, you may have noticed that whereas even a year or two ago, those commercials always kind of started out with, hey, have you been hurt on the job, or are you getting all the workers' comp benefits to which you're entitled? Call us, we're for the people, we help folks out. Lately, again, last year or two, the commercials have changed. And instead of talking about on-the-job accidents, the commercial says, are you being paid correctly by your employer? Are you getting all the overtime that you're entitled to? If you have any questions about that, you should call us For the People. So why in the world did one of the bigger law firms in our country that represents injured workers get into the wage and hour business? Well, there's a reason. That they have figured out, and the statistics for many years have been that something like 70% of the employers in this country do not pay their employees correctly, as far as the wage and hour laws would say to do it. They don't pay folks overtime correctly. And the big one, which we have kind of listed on the bottom of the screen here, is they just assume that if many employers assume that if you're paying someone a salary, that you don't owe them overtime, which is absolutely incorrect. It may be true or may not be true that paying somebody a salary means they don't get overtime, but it really has little to do with whether they're being paid a salary. Under the wage and hour laws, whether you get overtime has only to do with whether you are an exempt employee or a non-exempt employee, meaning you're exempt from the wage and hour laws or you're not exempt. And there are different categories and different ways of looking at that do not hinge on whether you're paid a salary. That's part of it, but it's not the tell-all. And folks like Morgan & Morgan have figured that out. And the reason they advertise for this is that they hope that employees will come in and they'll have not only a wage and hour case, but, and we've seen this increase exponentially over the last 4 or 5 years from our side of the fence, is what they really hope to do is to get an employee and get a group of employees, say all the maintenance workers or all the warehouse workers at a particular place, and bring what's called a collective action, which is a wage and hour class action, which can result in lots and lots of damages. If you as an employer are not paying your employees correctly, then under the wage and hour laws, you not only owe the back pay, you owe double that amount of money, whatever the back pay is, times 2, going back as much as 3 years. And then on top of that, you have to pay the attorney's fees for the employees. So you can imagine if you have a collective action of 20 or 30 employees, that gets into the hundreds of thousands of dollars very, very quickly. That's why Morgan & Morgan got into the wage and hour business. What I've also seen from that law firm and others is they'll look in a workers' compensation case, as we have up on the screen here for you. And all of you, I'm sure, are familiar that one of the things we have to do as employers in workers' comp cases is a form known as a WC6, which is the wage and hour calculation that you have to go through and list the total wages for the employee the 13 weeks before they were injured, from which we get an average weekly wage, and that helps us determine what their workers' comp rate if they're owed disability benefits. Well, that wage and hour information is a gold mine for anybody on the plaintiff's side of the fence who's trying to figure out, do I have a wage and hour claim here? Because if you look at that WC6 form, it will have hours worked, it will have whether overtime was paid, and they'll look at that and try to determine, was this done correctly? And again, I'll say 2 things about the employers who I've represented in wage and hour cases. I've never met an employer who was deliberately trying to underpay an employee. I've never met an employer who was interested in doing that. I've met lots of employers who were doing it wrong and were completely unaware of it. So that's where all this has come from. And so why this fits into a conversation about beware your comp case is not just a comp case is you should look at those wage and hour rules. You should look at these WC6s and make sure that when we're filing those, we're not handing over information to a lawyer at a law firm somewhere who's going to say, hey, we've already got the workers' comp claim going. Now we want a wage and hour claim as well. We have seen more and more of those
What's
come up.
the most common mistake, Dan?
2. One is overtime, is having somebody that somebody's maintenance worker, we'll just use this as an example, but I don't want to bother with whether they're working more than 40 hours a week. So I'm just going to pay them a flat salary of $800 a week, and that way I don't have to worry about overtime. that person is almost surely going to be entitled to overtime if they work more than 40 hours a week because they're not exempt. The classifications of exempt employees tend to have to do with the type of job you do, not how you're paid. So for example, professional employees, lawyers, we don't get paid overtime, we get paid salary, we're exempt from the wage and hour laws. So that's the first thing that people get wrong. The second thing is paying folks off the clock or not paying folks off the clock. Most employers, in a very common sense kind of way, will say, all right, look, we scheduled you to work from 8 to 5. If you show up on your own at 7:30 and start working, we're not going to pay you for that extra half hour because you're doing that on your own. We don't need you here at 7:30. We don't really care if you're working or not. We're just going to pay you for the schedule. That's wrong as well. What the wage and hour laws say is two things. You have to pay an employee for any hour, any part of an hour that they actually work, and you know about it and suffer them to work. What you have to do with the employee who insists on showing up off the clock is to say, look, don't come in until 8. If you keep doing that, that's a disciplinary issue, just as if you were showing up a half an hour late. And we're going to warn you about that. And if you don't stop, we're going to fire you. But what you can't do is not pay them for it, which is probably the second biggest thing that employers get caught on. So that's wage and hour. Any questions about any of that or about hiring or about return to work? I know those are three pretty broad areas, but before we get into catastrophic injuries. Okay. All right. So what about catastrophic injuries? I suspect that at least a few of you out there, if not most of you, have had a workers' comp case where you've seen this referred to, either in the notes from GMA or from ACCG or from the defense attorney, and may have wondered, what does that mean exactly? Well, if you recall from when we began talking today, workers' compensation benefits are paid if you get hurt at work, if your accident arises out in the course of employment, and there are caps of 400 weeks, roughly 7 years, on the disability benefits and medical benefits that you get under workers' compensation. So for the run-of-the-mill case, you're not going to draw benefits for more than those 400 weeks. When that 400-week cap runs, your claim is over, your benefits stop. The big exception to that is if your injury is catastrophic. What does that mean? What used to be it was very easy to understand. It was a very limited number of cases, and it was only designed to be an injury that was truly life-changing. And there was a laundry list of very specific conditions that made your injury catastrophic. For example, if you were paralyzed from an on-the-job injury, if you lost a limb, if you were blinded, if you had a severe closed head injury, things that anybody would look at and understand, this is not just a back sprain. This is something that is life-changing, catastrophic, and we should keep this person on benefits for as long as they need to be. So that's how it was originally designed. In 1992, there was a catch-all provision added to that laundry list so that your injury qualified as catastrophic if you had any one of those other conditions, or if you met this catch-all provision, which is essentially the definition that qualifies folks for Social Security disability. So what's happened with catastrophic injuries in our comp system ever since is folks who have had, let's say, a back injury in their 50s have applied to Social Security for disability benefits, and you can get Social Security disability if you meet this definition on the screen here for you, which is not being able to perform your prior job or other work that you're qualified for in the national economy. And if you follow the headlines, I won't go into all the details about this, but when the economy went south around 2008, 2009, it became much, much easier to get on Social Security disability simply because as folks' unemployment benefits were running out, Social Security disability program, I think, felt sorry for folks who didn't necessarily have a job to go back to and would authorize or extend their receipt of benefits. So if you've read about that in the papers lately, you've read about how that whole system is quickly running out of money because of how many people are on SSDI now. But how that comes home in our workers' comp system is some of those folks who have been hurt at work have attorneys who then go to the workers' comp board or come to GMA or to ACCG and say, hey, my client is on Social Security disability. That meets the catch-all definition for a catastrophic injury under the comp system. Therefore, the 400-week cap is gone and they can stay on benefits for the rest of their life. So when you start getting into settlement negotiations about a case like that, naturally their attorney is saying, well, if they're 53 years old, they have a life expectancy of 30-something years, Multiply that by the $20,000 or so a year they're getting in disability benefits, plus they're getting $10,000 to $20,000 in medical benefits every year. We want a few $1,000,000 to settle their case. That's where it starts to come home. And it's really all because our workers' comp system, in part, is tied to our Social Security disability definition. The even bigger issue, in a way, is this law that I'll bet most of you have not heard of, which is the Secondary Payor Act, passed in 1980, and very worthwhile and laudable purpose, which I've never met anybody who disagrees with. Just simply this: even if you go back to 1980, interestingly, Congress was already getting concerned about whether Medicare was going to be able to survive. It was already having financial trouble. So one of the easier things that they said, hey, this is something that's easy to do that will help, at least in part, is to make sure that Medicare is only paying for things that Medicare should be paying for. And one way of saying that is, look, if there's another form of insurance out there, whether it's workers' comp or a group health program or a car insurer, if somebody else is responsible for an injury and should be paying for that, then Medicare should not be paying for that. So maybe we can take at least that few $1,000,000 and make sure that the insurers who are supposed to be paying for that are doing that, not Medicare. Pretty simple notion. Nothing was done about that law. It was on the books for years, and I can remember from time to time being at seminars myself and hearing lawyers kind of bring this out and say, isn't it interesting, this law is on the books, but Medicare's never tried to do anything about it. Well, they finally did 20 years later. In 2001, they passed an internal rule through a memo that says, all right, look, all you folks in the workers' comp world, if you have a workers' compensation case and you're going to settle, and you have a claimant who's either already on Medicare or is likely to be on Medicare within 30 months, then we're going to tell you what we think you need to do to protect Medicare's interest. And if you don't do it, then we're going to reserve the right to come after you under the Secondary Payor Act, which entitles Medicare to sue an employer, an insurer, a claimant, the attorneys in the case, the claims adjusters in the case, anybody connected with the settlement. Medicare can sue for double damages. So whatever they wind up having to pay that should have been paid by the workers' comp claim, they can sue any one of us for. And their remedy for that is, if you want us to not come after you, then you need to do what's called a Medicare set-aside trust. That's a term some of you may have seen in some of the information about your cases. We refer to as an MSA trust. What is that? Well, this is Medicare's method for protecting themselves. And whereas I said a minute ago, the purpose of the Secondary Payor Act and the notion that Medicare shouldn't have to pay for what Medicare shouldn't have to pay, everybody agrees with that. I don't know hardly anybody that agrees with the MSA system, and here's why. What Medicare says to all of us in the workers' comp system is, if your claimant's on Medicare or if they're going to be on Medicare shortly, then you have to take a chunk of money and put it aside in a trust, a Medicare set-aside trust. And it has to be large enough that it can pay for their medical bills for this injury for the rest of their life. And that's their way of trying to make sure that at some point they don't come to Medicare and say, hey, I want you to pay for this now. Even that might make a little bit of sense, except the way that they require that trust to be funded assumes that the person's never going to get better, that they're going to have the same amount of medical treatment for the rest of their life, year in and year out, that they've had for the last 2 years. And this example that you have up on the screen here is how that played out in one of my cases over a 3-year period of time. That case was open for 3 years, and we kept trying to resolve the case, and we kept going to Medicare saying what needs to be in this MSA trust. And you can see that in the same case where the claimant's condition really didn't change much at all, the fellow had a pretty badly broken ankle, had surgery, and had recovered, was getting pain management, was getting some medications. But that what we were told needed to be put in the Medicare set-aside was $121,000 to begin with. A year later, it was $459,000. A year later, it was $216,000, and was eventually approved for roughly what it was to begin with. So that number jumps all over the place, and as you can see from some of those numbers, it really prevented the case from being settled, because under any realistic evaluation of the case, there was no way anybody was going to wind up spending that much money to cover this guy's medical treatment. So the solution Medicare has designed doesn't fit reality too well, and that interferes a lot with our ability to settle cases. And it's why in a lot of your workers' comp cases, probably you've seen some discussion on our part about, well, Are we going to need to think about Medicare here? Do we need to do an MSA trust? And if so, what do we need to do to make sure that that's reasonable and not so exorbitant that it really prevents the case from being settled? Where all of this finally winds up in terms of workers' comp and the other employment issues that come in, apart from the things we've talked about, is settlement. Something that becomes a real problem and a real dilemma. And interestingly, if you go back to when I started practicing law, not to date myself too much, the settlement of a workers' comp case was the settlement of a workers' comp case. We didn't worry about any other releases or whether the claimant was going to sue us for anything else. But we didn't have the Americans with Disabilities Act or the Family and Medical Leave Act or GINA or a lot of these other laws that we've talked about here today. And what started to happen after the ADA was you might settle a workers' compensation case, then the person show back up, and there's an example listed in this McNeil case here. Person shows back up and says, hey, I know you settled my workers' comp case for $305,000 a year ago, but guess what? I'm all better and I'm ready to come back to work and I'm ready for you to rehire me. And as you might expect, the employer in that case said, no, thank you. We've been down that road with you before. We don't care to do that again. And then turned around and filed a discrimination claim against them, claiming, look, they know I'm disabled. The proof of that is they paid me $300,000 for my disability, and then they refused to hire me. Now, the judge fortunately saw through that, and because of the very favorable facts in that particular case, the employer got out of it. But I suspect they weren't happy about the fact that they had to pay somebody like me to defend them and all of that, and go through what they had to go through to get a judge to finally say, hey, this is crazy. This person shouldn't be able to get $300,000 for a comp claim, then turn around and try to come back to work and beg for more money. So when that dilemma starts getting created, you start thinking as an employer about, all right, so if we're going to resolve a workers' comp case with somebody, how are we really going to resolve this? How are we going to be sure that if we settle with them for a reasonable workers' comp settlement, that we aren't going to then have to turn around and defend another claim somewhere down the road? It also on the screen, you see the problem, even if we were just talking about workers' compensation, the law in our system always has been, if you aggravate a pre-existing condition on the job, it's still a compensable event. So if you settled a workers' comp case with somebody and brought them back to work, and the very first day they re-injured that same area of the body that you just settled, it's a brand new claim. And in a way of speaking, then you really haven't settled much of anything, because now they're off and running on a whole new claim, and the money you paid them on the old workers' comp settlement doesn't counteract that much at all, if at all. So this is why we think about, when we're settling a workers' compensation case, first and foremost, are there any other active cases out there that we need to think about? If we have the workers' comp claim, it's imperative to know, have they also gone to the EEOC? Have they filed a discrimination claim? Have they filed a wage and hour claim? Let's make sure we know what all is going on, so that if we're going to talk about settling one of them, do we need to settle all of them? Are we content to settle one and fight with them about the others? Sometimes that's the case. Sometimes we feel so good about our defense on the other cases, or maybe we feel so good about our defense in the comp case, that we don't mind resolving the other ones separately and letting the other ones just take their course. But much more often than not, it makes very little sense to give the claimant or the employee money and ignore these other cases and just let them go on. So that's always my first question, is what other claims are out there, if any? But even if there aren't any active cases, we definitely need to think about, if we settle the case with this person, do we want them back at work? Sometimes the answer is yes. Sometimes they're a great employee, and our imperative as an employer is we need them back on the job. If that's the case, it may not be necessary to settle the workers' comp case. It may be that we simply do what the system was designed to do, which is you pay the benefits, you let the case stay open, or you close it because they're better, their PPD rating has been paid, and now they're back at work and life is good. But if we're going to resolve the workers' comp case, we're probably going to need to part company with this employee. And because of the reason I just mentioned, if they come back to work and hurt that part of the body again, whether it's the first day or 2 years from now, that prior settlement isn't going to help us at all. So what we're probably going to need to do, if we're talking about settling, is to include a voluntary resignation of employment. And what would usually go along with that is a separate release that we would have them sign that says, I'm settling my workers' comp case, but I'm also agreeing to voluntarily resign. So we're both going to go our separate ways. We're going to buy our peace. And I don't have any other claims that I intend to file against the employer. so that you know that when you settle the case, you really are done with them, and you're not going to come to work in a week or two and find a whole nother lawsuit that hasn't been resolved. Now, having said that, there are some laws and some things that can't be waived. So, for example, we can get a general release or a settlement that says, I've settled my workers' comp claim and I don't have any active discrimination claims or anything else that I intend to pursue. That doesn't prevent me as an employee from being able to testify regarding another coworker because I know something about their discrimination claim. It doesn't prevent me from filing an unemployment claim. There are some things that the law says simply can't be waived. And there are particular issues when it comes to age discrimination. The laws regarding age discrimination say that if a person is going to waive an age discrimination claim, they have to be given 20 days to consult with an attorney, and they have to be given an even longer period of time to change their mind if they wish to. I can tell you in the 20 years I've been drafting those kinds of releases, I've never seen that happen, but it's there. And if you don't include that in the release, then it's not a valid release. So that maybe apart from some of the things we've talked about in terms of hiring and return to work and so forth, maybe one of the most important things as an employer to understand is that when I have a workers' compensation injury, it really isn't just about workers' comp anymore. It hasn't been for a long time now, to be honest. And I need to think through, are there ADA issues here? Are there FMLA issues here? Is there any other way they might come at me, since they are perhaps in the hands of an attorney now who's going to be looking at all these things? And what's my end game as the employer? What am I trying to do here? Am I trying to get them back to work? Am I trying to cut ties with them? Because whichever way you're trying to go there, a strategy needs to be designed that helps you get there, and it needs to make sure that you don't solve one piece of the puzzle only to have a larger problem somewhere else. So as the title says, your workers' comp case is not just a comp case, really. It never has been, but you can keep it limited to workers' comp if you're simply aware of the potential issues out there and think them through. You have a tremendous resource with ACCG and GMA to call the folks there and walk through these things with them. If you have any questions, you certainly can call or email me if you wish. But that's the time to do it, is before things start happening, because if you do that, you won't need me, and you'll keep these claims from being filed, and you'll be able to minimize greatly the amount of legal problems that you might otherwise have to deal with.
We got a couple different questions here, Dan. So,
okay.
Do I have to provide workers' compensation insurance for part-time workers? And I'm not sure, it's kind of cut off after that. Let me see if I can see.
Okay.
I'm going to try and talk to him directly. Robert Davison, are you out there? Can you hear me? So it says if, and then it cuts off after it doesn't provide anything.
Okay, I think I can guess. So the first part of the answer is simple, and let me see if I can guess where it was going. The question is, do you have to pay or provide workers' compensation coverage for part-time employees? And the answer is yes. If they're all the Workers' Comp Act cares about is if they are your employee. If they're your employee, it doesn't matter if they're full-time, part-time, or whatever, they're covered. Now, what I wonder if this question might be talking about is if you have a cleaning company or somebody else who you think of as part-time because they're only out there one evening a week maybe to do some cleaning. Do I have to provide workers' comp for that, for those folks? And the answer to that is maybe not. As I said a second ago, workers' comp says you have to have coverage for your employees. You do not have to carry workers' compensation coverage for folks who are not your employee, but are an independent contractor. That is, they are a separate entity. They're not your employee. And there's a lot of factors that go into that, but this is an issue that many employers get wrong. Most employers draw that line based on who's on their payroll and who's not. And their way of dealing with it or thinking about it is, if they're not on my payroll, then they're not my employee and I can't possibly owe them workers' comp. That is not the law. That's certainly not how workers' comp looks at it. That's one fairly important factor. But what the law looks at is the totality of what this person's doing. And if you are controlling them in the same way and directing their work in the same way that you would an employee, then they're covered. So to use that kind of custodial example, if this is a custodial company who works for you all on Tuesday night, they work for a manufacturer on Wednesday night, and they're kind of all around town, well, that's truly an independent company. And they're just coming in when you're asking them to come in, but you're not directing, other than that, what they do. And the key there is the evidence that they're independent is they're not just working for you. But so those folks would be independent contractors, no concern about you having to provide comp coverage for them. But you can change the facts just a little bit. If you have a cleaning crew that comes in not every Tuesday, but every night, and they don't work anywhere else but for your city or your county, and you designate them as an independent contractor, but you're paying them by the hour. Maybe you have a supervisor who oversees what they're doing. That person all of a sudden starts looking very much more like an employee. And in that instance, it doesn't matter what you call them. It matters how you treat them. And maybe the easiest way to understand that is if we didn't have to provide workers' compensation based on what we call folks, we would call everybody an independent contractor. And we'd set everybody up that way, and we'd sign a little document that says you're an independent contractor, and nobody would have to do workers' comp. And I think the courts figured out a long time ago, we're not going to let you do that.
Again, so same person on one fighter position that is a job share position.
Uh-huh.
And that was regarding part-time work.
Okay, so a firefighter who's a job share position, I'm not sure I understand exactly how that works, but you do have to cover firefighters if they're volunteers and your city and county have elected to do that. Whether they're most volunteer firefighters and even a lot of paid firefighters have another job somewhere else, that doesn't prevent you from having to cover them with workers' comp. You still have that obligation. They may have workers' comp as well for their second job. For any injuries that happen, while they're there, and your comp coverage doesn't extend out there, obviously, but you would still have to provide coverage for them while they're working as a firefighter.
So the next question is, do you have to provide work comp for volunteers?
Okay, volunteers are a good question. Similar to what we're talking about. Workers' comp law extends coverage to all employees, and we've talked about how an employee isn't one if they're independent, if they're a contractor. Volunteers, strictly speaking, are not covered as well. So, but there's a lot of caveats and a lot of cases out there involving folks who weren't getting paid, for example, but were still covered. And the employer's argument was, well, they're not getting paid, they're a volunteer. But it gets back to what we were talking about just a second ago. Paying somebody obviously is a very big factor in trying to figure out, are they an employee or not? But the fact that you're not paying them doesn't make them a volunteer all by itself. The courts really try to find workers' comp coverage where they can. They view it as a coverage that they want to extend as far as possible. So what they're going to look at before they decide this person's a volunteer and they're not covered is, are they really volunteers? Is this totally up to them? Are they free to come and go as they please? They're under no obligation from you whatsoever to do this job. The closer you are to that, the closer you are to being able to defend the case and say, okay, this is just a volunteer and we're not obligated to cover you.
So here's a question. This question goes back to OT. We pay employees for 2 hours call-in pay. They would be paid the 2 hours, even if they work only 10 minutes. Mm-hmm. Should you pay overtime for the hours, such as the 2 hours would then become 3 hours? I understand you should, if they actually work the entire 2 hours, but if they would not, only say work 30 minutes, should this still be overtime if they have worked 40 hours for the week already? I have used the GMA helpline before, but is Dan someone that we can email with questions as a member of GMA?
Answer to that is absolutely, and the answer to your on-call is yes. So, and a lot of employers do this. So if I have somebody who's on call, rather than trying to figure out, if they were on call for 2 hours, but they only work for 10 minutes, how do I figure that out week by week so that I'm paying them correctly? What some employers will do is to say, look, I'm not even going to get into that. If you're on call for 2 hours, I'm going to pay you for that. And even if you only work 10 minutes, that's okay. That has just saved me the administrative hassle of trying to figure that out week by week. And I figure that it all kind of balances out because there's going to be other times when you get called in and you work the entire 2 hours. That's all fine. What you need to be really careful about, though, is that the flip side doesn't happen. They're on call for 2 hours, but they wind up working 3, and you just pay them the 2. You still have to pay attention to what the hours were that were actually worked. And then as far as overtime is concerned, on-call is like anything else. As long as the total in that work week period exceeds 40 hours and they get paid the overtime unless they're exempt.
So next question, are judges and commissioners eligible for work comp since they are not considered employees.
Yes, they are. Commissioners, and it's been a while since I've looked at this, but I believe it's the same for mayors and city councils, elected officials. It has to be voted that they will be covered. But if the county or city votes for that, then they're part of the coverage. And you're right, they're not employees the way we think of them, but there's actually a specific provision for that in the compact.
Very good. Great questions, guys.
Absolutely.
Thank you so much.
Thank you very much for being here this afternoon.
So again, Alicia asked a question, will the copy of the slides be sent out? I will send a copy of the slides and a recording to everybody that has registered for today's session. So look for that. If you will, Deborah asked, do you get a certificate? At this point in time, we don't plan to provide a certificate, although we may do that in order to prove that you have attendance. So Deborah will be sending those out based on attendance of all three of this series if you attend. And Deborah said, yes, I will need that. Very good. We'll get you that, Deborah. So thank you so very much, Dan. Really great job. A lot of great information. If you have any questions, I'm sure you can email those to me and I'll get those to Dan and he can answer those. He did that with the last presentation, and don't hesitate to do that. But thank you so very, very much. Please give us a call if we can be any assistance, and we will talk to you later.